Good morning, everyone in Business Law 2. I promised to put up a little summary or review of the things that I thought were most significant from Chapter 22 of Promissory Notes and Drafts. Again, I'm not the most professional presenter on video. I'm not real comfortable with it, but I'm going to try to go through it the best I can. I'll probably put up a few other videos, not necessarily for this chapter, but for chapters where I do find good educational material available from everything from the Khan Academy to many other institutions and colleges that put up very well choreographed presentations on material in the different sections related to the homework that you have to do. But chapter 22, promissory notes and drafts, an important chapter, dry stuff for most of us. I like it because some of the things that happened to me when I was younger and before I was an attorney were often a mystery to me. Now I understand the process a little bit more. Some of you may have already worked or are working in the banking industry and have some familiarity with the concept related to drafts, not as much notes. But a note is basically, it can be negotiable, and we're only talking really about negotiable instruments, and it has to meet those 7 requirements from previous chapter 21. But it's basically a promissory note is just like it sounds. It's governed by Article 3 of the UCC, if you want to get into the specifics of the actual statutory language. Some of you might go on and get very serious about commercial paper, negotiable instruments, and you'll study it much more deeply. And if you go into law school, I have a few friends or students even from the mountain in the past that are in law school now, and they're studying commercial paper, Article 3, and it gets in more depth. And it's a well-written law. A lot of times when you read law, it's like, oh my God, it's so boring and drudgery to read through the statute, but actually the UCC, the Uniform Commercial Code, is written quite well and written practically so businesses can function. So anyways, who are the parties to a note? It's basically a promissory note. There's 2 parties, the maker and the payee. There's not a third party like drafts. Drafts have 3 parties, right? The draft, in a draft, it's the drawer, say it's me making a check. I have one bouncing around here somewhere. It's me making, I had a check out before. You know what a check looks like. But if it's my bank account, there's 3 parties. I am the drawer. I will sign on the front. Don't call that an endorsement. Call that a signature. I sign on the front, ordering Bank of America or Hometown Bank or Cornerstone Bank. That entity is the third party. They are the what? They are the drawee. I'm the drawer. They're the drawee. And the person I'm paying or wanting to transfer funds to, they're the payee. So drawer, payee, drawee. And it gets, I know sometimes okay, I get it. And then 5 minutes later, you lost which one was which. It's open book tests. It's open material. Over time, you'll get accustomed to the different kinds of terms. You're obviously, if you're the maker of the note, you're liable to pay the amount of the note unconditionally. If it's conditional, it's not a negotiable instrument. Doesn't mean it's not enforceable between the parties. It's just not negotiable. We know that's important later on, that when the original payee tries to transfer the note through negotiation, a future holder can be called what's called a holder in due course, gives them special rights to collect, and certain defenses can't be raised to them. We haven't gotten to that yet, so that part of it remains a mystery, and I know it gets confusing for students. Like, why do we care about negotiation when you can simply do it through assignment? Assignment just simply only gives you the rights that the payee had, which may not be nearly as significant as a holder in due course might have to actually collect and enforce upon a note. There's certain admissions when the maker makes a note that the payee actually exists, and the payee is competent to transfer the note in a future time. Competence is always a very low level in most areas of the law. It's presumed. Someone who alleges a lack of competence has to prove that. Usually it's through doctor's reports or the like. Very, very difficult to establish. So types of notes, bonds. All a bond is a written obligation to pay a debt, usually issued by a government or a business. They usually carry the full faith and credit of basically the strength of the business's financial resources. And obviously, if it's a town or a municipality or a state government or a federal government, it carries the full faith and credit of the government. Government bonds tend to be very stable, but governments, not necessarily the federal government, but state governments, I don't know about state, but I know municipal governments have gone bankrupt in the past, and the bonds might not be repayable. But it's sort of an investment. Usually that's what a bond is. You're basically giving money to the government, and they're promising to pay you back at a date certain. That money, the principal, plus some form of interest. And that's all a bond is. Companies do the same thing. There's no right to necessarily take over the municipality's properties, whether it's trucks and cars and tools and the like, or their buildings and land if they don't fail to pay. It's not what we call a collateral type of lien. Same with the businesses. If they fail to pay, you might have a lawsuit against them, but chances of they fail to pay, they're going to be protected by bankruptcy potentially. The two different kinds of bonds the book went over: coupon bond, that's literally it's almost like a booklet, and you get a little tear off, and you can collect portions of it as you go along. You present it, and they pay as they go. They are not registered with the company, so they're negotiated by basically passing the bond document to a third party. The problem with that is if it gets lost, stolen, burned, destroyed, there may be difficulty proving its existence as viable, where a registered bond is just that. It's registered to a specific owner, and if that specific owner wants to transfer it, they have to let the obligor, the party that has to pay it back, the municipality or the business, they have to be told of the change in registration in case that bond ever should get destroyed or lost. The holder can still collect. Collateral notes, very important. It can be on intangible property like stocks and bonds, or it can be on personal property like a car. Many of you might even have a car right now. My wife just bought a car, and we didn't buy it outright like most people don't. You get it, especially with the good financing terms. We financed it, and that's exactly what we made. We made basically a collateral note. A note is a promise to pay. We promise to pay them back the money with a certain amount of interest at time certain, date certain, on an installment plan, and they have collateral. What does that mean? They reserve title to the goods. We get to use the goods, and we have an interest in the goods, but we do not have title to those goods right now. Toyota Motor Corporation doesn't happen to be a Toyota. And some of you are familiar with that. You can actually buy, companies do this too. Like if I was opening up a restaurant, I might need new ovens and refrigerators and things like that. I might not be able to finance that through the bank. I might finance it directly with the different those are called refrigeration companies, but different appliance companies that serve the commercial businesses of restaurants and the like. They may give me a collateral. I'd give them the collateral note. I am the issuer. I am the maker of the note. They are the payee, and they'll put what's called a security lien upon those pieces of property. They'll register it with the Secretary of State and usually in the town. It's called the UCC filing, literally UCC filing, related to this very topic to protect their interests if the note's not paid in a timely fashion as the terms require. Real estate mortgages, and that's what's interesting. This is hopefully just a practical portion of the course. When you take out a loan to get a home, you basically are going to use two major documents. One is the promissory note. You take out a $200,000 loan to buy your first home. You promise to pay them back on an installment payments, and there's going to be 5% interest, whatever it is. That's what you actually pay each month. Everyone says I'm paying my mortgage each month. You're not really paying the mortgage. You're paying the loan note. The mortgage is the security interest on the real estate that says if you default on the loan, they have the option of taking the land or home or whatever it is that they gave you a mortgage on. It's usually real estate. They have a right to foreclose, sell it, and they have to sell it at the best price they can get, and you're entitled to any overage. Like, so say it was several years down the road, you only owned $100,000 on that note, you failed to pay the note, they could either sue you just on the note, or they could sue you on the note and mortgage, or just on the mortgage. Now, say they do foreclose upon you, they sell it at auction, foreclosure auction, and they get $150,000. Well, all you owed was $100,000. You'll get the remaining balance of the $50,000 minus expenses of going through the foreclosure process. And that's a type of note. That's a practical part of this class. Some of you might get into more sophisticated business ends of things, but even my sister, for example, my sister's not a lawyer. She's a business person. And my dad is certainly, well, he's dead, but he wasn't a business person. But for whatever reason, he always seemed to be able to squirrel away money. My sister's in the real estate industry, not as a big player or anything like that, but she likes to buy 2-deckers and 3-deckers and fix them up and rent them out. And she likes to hold real estate. And she always was capped out. She was always borrowing so much money from the bank that her credit was a little bit at risk. So she couldn't get new loans. So she tapped my father for money. And guess what they would do? And this was even before I was a lawyer, but after I was a lawyer, they asked me to look over the paperwork. they would take out a loan. I'd ask them not to do a mortgage because I didn't want my father to have to foreclose upon my sister. But we did do a mortgage. We just simply didn't register it. You don't have to necessarily file your mortgage at the registry of deeds. You should, because it gets you first in line ahead of other creditors. But between my sister and father, they didn't want to do it. But my father wanted to be protected in case my sister should die or something weird should happen like that, that my father would be able to collect if my sister or her real estate company would be failing to pay. He'd be able to get his money back by foreclosing upon the collateral. That's what collateral means, a collateral note. Pretty clear, straightforward. Debentures, I always like to say, oh, I've issued a debenture today. All a debenture is a company, an unsecured bond, promise to pay back money, a company issue. Sometimes it's fancy, formal-looking paper. Look at me, I came home with a bunch of debentures today. It's just an IOU from usually a company. Certificates of deposit, that's when you or somebody pays money, or gives money to the bank. They promise to receive it. They take it, they acknowledge the receipt of it. They promise to pay you back those funds and more based upon the interest rate on the certificate deposit. Why do we care about it? Well, it's negotiable. That you, as the owner of the certificate deposit, may have the power to either transfer, which we're not talking about so much in this course. We're more concerned about the power of negotiation, that unconditional right to receive monies at a certain date and time that can be transferred to a third party. Certificates of deposits. They're not as big right now because interest rates are really low, but when they go up, it becomes a viable investment for people. Now, the second tier of this chapter is drafts, and there's different kinds of drafts. The ones I'm going to focus, is checks, because it makes it more tangible to most students to understand a check. But drafts is basically an instrument by which a drawer orders a drawee. It doesn't have to be a bank, but for practical purposes, it makes most sense. But someone could actually issue a draft today. I'm thinking of my friend, the mechanic. I have a mechanic friend that comes over, does work on all my cars. I have cars that are always in chronic need of work. And, say I owe him some money. He could, in theory, write a draft against me. He'd be the drawer, I'd be the drawee, and he could give it to somebody else he owes money. So say someone, his friend Fred, who knows me too. He could say, Fred, I need $500. I'll give you a draft against Corman. And say Fred is kind of aware of our relationship, that I owe him money. That's actually a viable draft. There's three parties involved in the draft. The drawer, my mechanic friend Ron. The drawee is me, the one who's going to be presented with the obligation to pay, and we'll talk about whether or not I have to pay later. And then Fred is the payee on the third party. But for purposes of this class, I think it's a lot easier to think of checks. The drawer is the owner of the bank account, the drawee is the bank, and the payee is the one that's going to receive the unconditional order for the drawee to pay that money. Trade acceptance, that's related to basically taking things on kind of consumer debt. So I'm a restaurant, I buy this oven that's going to cost $10,000 to make pizzas at my shop. And I don't have the money, but I'll draw up a note, or I shouldn't say a note, I should say a draft for the oven company will draw it up, and they'll make me the drawee, and I'll have to pay some third party, a creditor, or their bank at some later date. Give me a chance to finance, basically hold on for a period of time before I have to pay. That's a trade acceptance. Draws on obligated to pay until the drawee accepts the draft. Basically, that's when you present, say I get paid by somebody from check. When I go to that bank, the bank it's drawn from, not my own bank necessarily. I go there and I present it. That's presentment to have it paid. Usually they accept and pay in the same moment, but they don't always. We know there's going to be a time draft later on where they accept, and then you'll be eligible to collect 10 days later, 6 months later, depending on the terms of that draft. That's called a time draft. Most are demand drafts. You just go in and you present it upon site versus a time draft. But you should know about time drafts. You do that. It's not usually a bank involved. It's usually a third party. Someone presents me with an obligation to pay. I accept today, but right in the terms of that draft agreement might be that it's payable 6 months later. But it's 6 months later than what? Later than from the time I accept it, agreeing to pay that obligation. Forms of acceptance, usually it says something accepted. The banks usually have stamps for that. Certain admissions of the acceptor that agrees to pay the instrument when it is due. If it's usually site drafts due at that moment, but those time drafts are due at the dates suggested or articulated in the draft itself, admits that the drawer's signature is genuine. Remember, I have a relationship with Bank of America. So usually in smaller checks, they don't do it, but on larger checks, they will actually pull a file. Now it's probably electronic, but when I was a kid, I remember they would actually have like little drawers and they would pull out my file and they would compare the signature that I have on my account with that I put on my draft in order to determine whether it's true. Because if they cash a forged check, I find out about it in a reasonable time and give them notice, I won't be liable. They will be. And so that's why they want to ensure it's done. And sometimes if it's a big enough check, what do? They actually get on the phone sometimes. They're very concerned about them being at a loss because I won't be liable for forged instruments as long as I wasn't negligent in that process. Basically, somebody ripped me off, stole it, broke into my car, got a check, cut it to themselves, and signed it. And I give the bank reasonable notice upon learning of that forgery. The bank has to return those funds to my account. So that's why they have the duty to be cautious with regard to those things. Money orders. I still use a money order once in a while. Basically, it's just that. It's almost like a cashier's check or a bank check. It's pre-accepted or it's based upon the funds of the drawing institution. So we know it's going to be good. Special kinds of check. A certified check. A certified check is if I take my own check and I bring it to the bank and I'm going to send it to my buddy, Ron the mechanic. And I write it out to Ron the mechanic, but I want it pre-accepted. That's certified. Basically, the funds are there. They're going to be held in reserve for Ron, and it almost acts as if cash. And I won't have the ability to do what? I won't be able to have the ability to stop payment on it. It is much more desirable by Ron, the payee, to get a certified check. The last time I tried to get a certified check from Bank of America, they wouldn't give me one. They'd only had what we call bank drafts. So I'll get to that in a second. So it's again, a certified check is a check that is accepted by an officer of the drawing bank ahead of time. They've reserved the funds. They've already acknowledged it will be paid when actually presented. It's pre-accepted. It's similar to these. A cashier check is the one that the bank would give me. And some people call it a bank check. It's not quite synonymous. But a cashier's check is just that. It's drawn on the bank itself. So basically, I'm giving Ron a check for $10,000. I paid the bank already, and it's drawn in the bank's funds, and we know it's going to be made good. So it's very, very favorable to the recipient. A bank draft is a check drawn by one bank on another's accounts that are in reserve there. Voucher checks are pretty cool. I've used them in, not me, but one of the firms I use in. We worked in a very, very large firm, and we used to use voucher checks for everything. It helps keep track. All it is a check, and there's an attached section of paper on it, and it helps articulate what the check is for, and it's good for bookkeeping and just keeping records of why you sent checks for different kinds of things. Occasionally, I'll do some weird little thing for some company or entity or something like that, and I'll get a small stipend or something, and on it will be the voucher. It states the purpose for its issuance. I like that as a recipient. I would like that as if I had a big enough company or a big enough law firm or something like that, and I was issuing a lot of checks. Voucher checks really help me, I think, keep better books. Nowadays, everything's electronic. Maybe it's not as important as it once was. And traveler's checks. All traveler's checks they're very similar to cashier's checks, meaning they're based on the bank's finances, pre-acceptance, but it requires a signature and a counter signature. So when you buy them from the bank, it's almost like buying money orders, but you have to sign them at the time of buying. But then there's a second signature required at the time you want to issue them. It gives you some security in it. I guess people still use traveler's checks. I'm just not great at details in life. When I travel with other people, I'm thinking of the past, like, we have to go to traveler's checks. I'm like, I'm just taking cash. I'm not credit cards. I'm not gonna, I don't know. I just felt a little nerdy for some reason. Maybe it's not. Maybe it's very appropriate. I guess once you lose all your cash, you learn your lesson, right? When I was younger, there was commercials for traveler's checks all the time. Like it was the biggest deal in the world. But I think credit cards and debit cards have really changed a lot of that. Post-dated checks. Be careful about post-dated checks. If I issue a check today and I know I don't have the funds and I tell you, hey, look, don't cash this until March 1st. I'm going to even date it March 1st. Can the bank actually accept it prior to that? Yeah, unless you notify the bank, other than on the check. This surprises a lot of people, and this happens. People say, all right, yeah, I promise. And what do? They go down next week. They don't wait till March 1st or whatever the dates are. They go and cash it early. and the bank comes back and bounces it and says there's insufficient funds, or they do cash it, but you needed that money for something else and you were waiting for a deposit of money in 2 weeks from some other source. You have to notify the bank about a post-dated check, or they simply don't have to honor it. They don't have to catch it. Bank is not liable for paying a post-dated check before its date unless the drawer, meaning the person with the bank account, gives bank prior notice of it. Bad checks. You got to be worried about bad checks. I do a lot of criminal defense. I don't know why I'm pointing in the back as if that shows I'm a criminal defense attorney. But I do a lot of criminal defense work, and I've done a lot of things on bad checks. Most people don't write checks knowing they're bad, but some do. And how do we determine that? The defense is, oh, I didn't know it was going to be bad. I'm like, well, but the bank notified you months ago, and you didn't do anything to rectify it. And that's really the test to show a presumption of criminality, is if you don't make good on checks that bounce within a reasonable time of being notice of insufficient funds. One thing I do recommend, just for practical purposes, you can set up a bank account with what I call overdraft, usually to let you, my son's notorious for it. My son actually does very well financially, but he's very poor at his management. And we've got him overdraft protection of, like, on his account, I don't know, like really high, like $1,000. And so the bank will actually front him the money, and they notify him right away, and he makes good on it through electronic fund transfers all the time. But other than that, you don't want to get caught with criminality. And I'll be honest with you, most courts will simply dismiss a bad check case upon payment of what the bank is injured by, and the bank does get injured sometimes by these things financially. Stale check, usually anything that's over 6 months old is stale. I don't know, and the book doesn't cover it well. What if I have checks and I say not valid after 90 days? Well, that might be an obligation between me and the payee. I don't know if the bank necessarily has to honor that. That's an interesting question. Stopping payments, a very interesting issue. You can give notice to stopping a bank prior to its acceptance. You can do so with oral, just calling them up on the phone. I don't know how you prove you did it, but that's only good for 14 days, and it can renew by up to a year by written notice, and then you can keep renewing it in case you're worried that check is out there because maybe 2 of them were issued or something like that. One was lost and you're issuing another one. And remember, now the bank is only going to be liable for screwing up between the person with the account and the bank. The payee never has rights. And I used to think this all the time. Back in the day when I had a job at another firm, I used to get a paycheck every 2 weeks, and I was a cash kind of guy. So I'd go cash those checks. This is before everything was electronically done. So I get my checks every 2 weeks, and I go to the bank and I cash them. And I knew enough not to present it to my bank because they're not the drawee. I present it to the bank from which it was drawn. So back then, I think it was called Fleet Bank. I don't even think they're around anymore. So I go to Fleet Bank, and guess what Fleet Bank would sometimes do? They'd sometimes not accept the check. And I'm like, well, why? He goes, well, we're concerned about something, whatever it is, not that it was bouncing. And I'd be so mad. I'm like, but there's an unconditional promise from the drawer ordering you, the bank, to pay me, and you're failing to do it. And I think, I'm going to sue you. I can't. Why? They have no liability against me. I am not their customer. I do not have a contractual relationship with the bank. Now, could I go back to my employer, the law firm I worked at, and says, hey, Fleet Bank's giving me a hard time every time I cash this thing. I want you to take action against Fleet or change the account. You could try to put pressure on them that way. But the relationships are independent on some level. And when the bank does accept the check, they are warranting that the drawee, the law firm, actually did endorse that check. They're not warranting that when I sign the back of that check as an endorsement to negotiate it to them for presentment, they are not acknowledging that that is in fact my signature. They don't have liability for that as it gets signed out further and further. A bank customer's responsibility. A bank customer owes a bank a duty to examine bank statements and notify the bank within reasonable promptness. And that's a question. What is reasonable promptness? UCC suggests it's even up to a year you can give notice. I would suggest within the 30-day cycle of getting a notice that you notify the bank of any irregularities, because your actual contract with the bank may suggest that if you don't give notice after a period of time, you're liable for the risk of loss of forgeries or unauthorized activities in your bank. Yeah, it says a customer who fails to report an unauthorized signature or alteration within 1 year cannot assert the loss against the bank. I would suggest doing it monthly. Check those. Brief little summary. Hope to put up some other things. I'm trying to keep these things kind of brief. I know I didn't get too thick into the weeds. This is an introductory class. I think a lot of people don't like this material, chapters 20, basically the promissory notes, commercial paper, Article 3 stuff. I promise it does get better. But stick with it, do the readings, and look at the other videos I post too. If I do post some up in this section, I think they're going to be even better than anything I say or the book does. And test or open book, I think they're straightforward, so hopefully you enjoy this material enough to say it was worthwhile plodding through it and you know some basics about commercial paper.